so I think she'll be joining us now. Fatma, do let me know when we're live.
I think we're live right now. It's started.
Assalamualaikum. I'm Hania Rifat, and I'll be. There's some distortion. Mute, please. I'm Hania Rifat, and I'll be co-moderating today's session on behalf of the Youth General Assembly. I welcome all esteemed panelists to the second session of our 6th Beyond Youth Conference that is being co-presented by Youth General Assembly and Adil Aur Sehat Project. We are very grateful to CEO Adil Aur Sehat, Ms. Khushbaksh Jilani, and Director of Programs Adil Aur Sehat, Ms. Fatma Khan, who's also joining us today to have this session dedicated to gender and criminal justice reform. Ms. Fatma, we'd like to hear more from you.
Thank you so much, Hania. Hello everyone, my name is Fatma Khan. I'm the former Fellowship Programs Director by the Adil Aur Sehat Project, and we are extremely delighted to collaborate with the Youth General Assembly in this forum because we believe that the main mission and the ordinary message of the Adil Aur Sehat Project and the Youth General Assembly is to promote and spread legal awareness and health awareness as well, especially through online platforms. So thank you so much, Hania, for having us as well. And thank you to all of the members and the team of the Youth General Assembly as well.
Thank you, Fatma. Surge in recent events, a surge in gender-based crimes and some gut-wrenching incidents also surfaced. So it became crucial that we have an in-depth discussion on the matter. In order to provide an insight into this and much more, we have a dynamic panel of 4 highly accomplished professionals joining us today. I'll take the honor of introducing Barrister Mehrunisa Sajjad. Barrister Mehrunisa is an associate at Raja Muhammad Akram and Company. She completed her BA Honours from Oxford University and also served as the Vice President of the Oxford Union. She is a recipient of the Vice Chancellor's Women Leadership Award. After completing her graduate diploma in law, she was called to the bar by the Honourable Middle Temple Society. She is frequently seen advocating for gender justice. Barrister Mehrunisa, it's an absolute pleasure to have you with us.
Thank you so much. It's a pleasure to be here. And thank you so much for having me.
So the next guest that we will be introducing for this panel is Ms. Farah Khan. Ms. Farah Khan is a special prosecutor at the National Accountability Bureau in Pakistan. She is also serving as a adjacent faculty member at the Hamdard School of Law. And she has also previously worked as a research associate in the International Commission of Red Cross. And she also has experience working as a research associate at the University of New York. So thank you so much, Ms. Farah Khan, for taking out your time for us as well.
Thank you very much for inviting me, and I think it's an honor to be part of this panel.
Thank you, Miss. Joining us today is also Miss Noor Ijaz Chaudhry, who's an advocate of the High Courts of Pakistan and holds an LLB honours from the University of London. She completed her LLM in Human Rights, Conflict and Justice in 2019 at SOAS University of London as a Chevening Scholar. Ms. Ijaz works closely with senior advocates of the Supreme Court and High Court. She has formerly worked with the Senior Advocate Supreme Court of Pakistan, Ms. Asma Jahangir, as the legal associate up till Ms. Jahangir's death in 2018. She has worked on various notable human rights cases in Pakistan, including the Orange Line metro train case to protect the cultural heritage of Lahore, cases regarding the disenfranchisement of women voters in the north of Pakistan, and cases to contest the scope of judicial review for decisions passed by military courts. Her publications and research include case law trends in the freedom of speech and expression in Pakistan, refugee rights, and freedom of religion and belief. She currently leads her own practice in Lahore, where she specializes in constitutional, labor, and civil law. She also teaches LLB students at a local university. Ms. Noor, it's an absolute pleasure to have you with us today. Ms. Noor, there's some vibration from your side that indicates that you're speaking, but it's very unfortunate that your voice is not clear. Maybe you could reconnect from another device or even try changing your connection, if that maybe works. So we'll begin the formal session by the first question that was planned for Ms. Mehrunisa Sajjad. So Ms. Mehrunisa, when we talk about the criminal justice system, the first step is evidence collection and evidence handling. I would like to bring the attention of the panel to DNA evidence, which is very crucial when it comes to gender-based crimes. So when we see when we draw a comparison between DNA used as an evidence in paternity issues, it is conclusive. But when it comes to rape or like sexual crimes, DNA evidence is not conclusive. How do you comment on the overall process of evidence handling in Pakistan, especially in gender-based crimes?
So I think the problem that arises in most cases is once a case or an FIR is registered with the police, and then you have investigation officers, etc., trying to collect evidence from that point forward. The first problem that arises is actually resistance of the police to register an FIR. Often in cases involving domestic violence, etc., the police tries to convince the parties or the victim or the complainant to actually mediate and to not register an FIR. And it's a very complicated, there's very complicated politics surrounding the whole system. Obviously, a higher number of FIRs registered also reflects poorly on the police itself. So I think as a victim or as an informant, going in and registering an FIR is also an extremely arduous process. This coupled with the fact that any woman who's coming forward and registering such a crime is also dealing with a lot, perhaps at home and in society, a lot of pressure to not report the crime. So that's the first problem. Secondly, the problem is that in the whole process of evidence collection, the FIR, which is supposed to be a procedural device, is treated as completely central to the entire trial. So what goes down in the FIR is treated as biblical almost, right? So, and this is a problem that keeps arising. The way that statements are recorded, the way that evidence is collected, there's a lot of connivance often that sort of in the backdrop that goes into collecting this evidence. Also, the fact that all versions of the same event are often not recorded, or even when an accurate version of what the informant is saying is not recorded in the FIR. And going on forward from there, there are a lot of issues that come up in the trial as well. And I mean, we've had case law on this. We had the Sugra Bibi case where attempts have been made by the judiciary to reform this process. But also another very important point in evidence collection is the fact that we need to move towards more modern methods of evidence collection. We need to move away from relying more heavily on eyewitness accounts, and we need to start looking at circumstantial evidence as a whole. And obviously also using DNA and other scientific evidentiary devices more. So I think what is required is essentially a whole revolution in the way that you are examining evidence, in the way that you are collecting information, especially in cases with sexual violence. Another problem that comes in evidence collection, and this is also when you're recording statements of the witnesses or the victims, is the surrounding atmosphere in which this evidence or in which their statements are collected. Most police stations and even courts fail to provide a safe and comfortable space for women where they do not feel triggered, where they do not feel like their trauma, that they are reliving their trauma. And I mean, making provisions of video link, for example, for victims who perhaps do not feel comfortable coming to a police environment or coming to court, so that they can record their statements or they can give their evidence in a space where they are feeling comfortable. Another thing, I think it's very important that we need to have more female investigation officers. And perhaps in cases of a sensitive nature where you are dealing with sexual abuse or violence, perhaps we need to look into having only female investigation officers so that the female witnesses or victims who are survivors who are coming forward are feeling comfortable when they are, recording their evidence. So if the environment in which the entire process of evidence collection or investigation is taking place is so intimidating for the informant, for the witnesses, that actually has an impact on the quality of evidence that is collected. That is one problem. The other problem is also the fact that often the police is in connivance with one side of the, with one party. So what is stated or the evidence that is found is actually not an accurate representation of what is eventually recorded. So, I mean, there are multiple layers to the problems surrounding evidence collection and investigating crimes. And I'm sure that Noor and Farah will be better able to add to this further and illuminate this point.
Yeah, well, you rightly pointed out that there has to be a safe and comfortable space at the very beginning when the case is being reported at the police station for a proper collection of evidence that could eventually result in conviction, because as you said, that it has a biblical status, the FIR. Moving on to Ms. Farah. Ms. Farah, would you concur with Ms. Mehrunissa that the basic problem when it comes to prosecution of criminal... Ms. Farah, are you there? I think she has disconnected because of some internet issue. So we'll move to Ms. Noor. Ms. Noor, can you hear us? So it turns out that Barrister Mehrunissa will have to pose the second question. So Fatma, you can have the second question first, and then when Ms. Farah rejoins, we can take a stance on this.
Okay, perfect. So, Ms. Mehrunissa, you spoke about police attitudes and you spoke about how the police can serve or have pre-existing biases as well before the female victims come to the police station, right? So, in terms of that, what are some of the anti-corruption practices that you think are already in place that kind of reinforce the accountability mechanism of the police? So, since we're talking about the criminal justice system and the way that these police investigations are carried out, who are the exact stakeholders that are responsible for determining police accountability? What are some of the enforcement mechanisms, in your opinion, that kind of determine that there are certain anti-corruption strategies and practices that are in place that kind of, keep the police in check as well? So this question is directed to Ms. Mehrunissa, but I see that Ms. Farah is back. So Ms. Farah, you can kind of go at it first, if you like.
I'm so sorry, the connection was lost. Can you please repeat the question, because I've heard till the accountability portion, whether the police is there any mechanism for holding police
accountable? Have your stance on the previous question?
So can we have your opinion on...
Yeah, Ms. Farah, we wanted to have a question, your stance on the question.
Yeah, so okay, so what Mehrunissa was saying, to just in addition to that, before we talk about the investigation and collection of evidence and all of those factors which are very important, we need to see that how society looks at women when the woman enters into the system as a complainant or as a victim or as a witness. Unfortunately, the whole society is so hostile towards a female litigant, be it a civil proceeding, be it a family matter, be it a mother fighting for the custody of her children, be it a woman fighting for the maintenance from the husband or protection or whatsoever. It is a very hostile system, and it is very difficult for a female litigant to actually step into that system and fight against this the legal structure that we have, which is fundamentally misogynist and fundamentally patriarchal, right? So they are discouraged, they are threatened, and a lot of questions are raised on their characters and their stability and their strength as a woman or as an individual citizen in the country. So, this is something that we need to understand, because these are the people who are eventually running the investigating agencies. These are the people who are prosecuting for them or against them, and these are the people who are going to pass a verdict on a complaint which has been brought by a woman, right? So we see that there is a lot of judicial bias, there is a lot of administrative bias towards female litigants when they step into the system. I'll give you a very small example. For example, rape and sexual assault, these are very serious matters, right? But say that I am standing on the road and somebody comes and snatch my mobile away, and I want to go and register an FIR. I have to step into a police station which is everywhere I'm dealing with men, right? And the first question they will ask me, although I am not talking about any sexual assault, I'm not talking about any eve-teasing incident, they will automatically assume कि मैं कुछ कर रही होंगी जब भी मेरे साथ ये हो गया, ठीक है? मेरा मोबाइल लेके कोई चला गया और मुझे पहले पुलिस ऑफिसर को ये जस्टिफाई करना है that I am worthy of his attention as an individual, not as a woman, right? So this is the first step that a woman complainant or a witness have to pass. Once she crosses that hurdle and the FIR is registered, then the matter goes for investigation. Now, unfortunately, it's a very common concept that we do, and we blame the judicial system for delayed justice. We blame the judicial system for delayed prosecution. But before all of that, before a matter goes to court, it is the police, it is the law enforcement agency who are handling everything. And if everything is ruined from the very first stage, from the moment the FIR is registered, and when the challan is fired, important witnesses are not there, important evidence is not there, and even if the evidence is there, it is so badly handled that it is absolutely destroyed. I'll give you a very small example. Right now, this case, which is like, everybody is talking about, this Noor Muqaddam murder case. The pictures of the IG police at the place of incident are being viral. Like, look, Islamabad police has taken some actions. No, he is not supposed to stand at the place of incident and take pictures. It is a scene of crime. Everywhere there is DNA evidence. It has to be sealed. It should not be open for a photo session, right? So these are the basic mistakes that the police makes. This is a very high profile case. We expect police to be at its A game when we talk about high profile cases. But for me, as a complainant, as somebody who's a victim of offense, although I'm not very important for state, but my case is high profile for me, right? But we need to see the conduct of the police when everyone is watching them, they're making these blatant apparent mistakes in investigation. So just imagine what they will do when there is no one watching them over, or there is no media hype, or there is no discussion on the television, how badly they will investigate, right? So if a challan is placed before a judicial magistrate where the DNA evidence has been collected after 72 hours, the forensic science says that after 72 hours, it becomes impossible for a forensic expert to actually conduct a test on the DNA evidence and differentiate which DNA is what. Okay? And if the DNA is not preserved properly, it has not been sent to the laboratory on the in a particular time lapse. If the person has been taken to the MLO and the MLO has failed to examine the victim properly, the clothes are not seized, or anything which the victim was wearing at that time, that has not been examined properly, and that challan is placed before the judicial magistrate for his judicial scrutiny. What is he going to do? He is going to either accept the challan and forward it for trial, or he's going to order for a reinvestigation. But what will a reinvestigation achieve in that case when the evidence has already been lapsed? So, our focus, our reform should be towards these law enforcement agencies, and we have to pay a lot of attention in their grooming. Now, there is another infrastructural setback that we have. We don't have forensic laboratories. We have one in Karachi, we have one in Islamabad. Islamabad सैंपल जाता है, वो कहते हैं जी एक्सपर्ट नहीं है, वो कराची भेज देते हैं. कराची वाला कहते हैं हमारे पास फलाना माइक्रोस्कोप नहीं है. तो वो तो सैंपल आप इधर से उधर भेज के ही आपने डिस्ट्रॉय कर दिया ना, तो उसकी तो सैंटिटी वहीं खत्म हो गई, चेन ऑफ एविडेंस खराब हो गया. So it becomes impossible for prosecuting agencies or prosecutors to actually prosecute on such weak evidences in court. So this is one thing. And when we talk about criminal law and gender, as a society, our approach towards gender-based crime is so discriminatory that there are so many biases, there are so many presupposed notions about the case. वो वहाँ क्यों थी, उसने कुछ किया होगा, उसने बहकाया होगा, हम पहले से ही वो पुल बनाने शुरू कर देते हैं for the accused. हम victim shaming पे believe करते हैं, हम victim के कैरेक्टर को assassin करते हैं, हम हर वो चीज़ कोशिश करते हैं जो कि leverage देता है accused को at the end of the day court. और ये पूरा societal problem है. इसके अंदर वही लोग शामिल हैं जो इन्वेस्टिगेट भी कर रहे हैं, इसके अंदर वही लोग शामिल हैं जिन्होंने आगे आकर जजमेंट्स भी देने हैं. अगर आप सुपीरियर कोर्ट्स की फाइंडिंग्स पढ़ते हैं, मेहरुन्निसा ने बहुत अच्छा पॉइंट रेज किया दैट वी हैव टू मूव फॉरवर्ड फ्रॉम दिस ऑक्यूलर एविडेंस फिनोमेना, दैट वी हैव टू हैव एन आई विटनेसेस. There are cases where there are no eyewitnesses. It's a completely blind incident. How is the investigating agency prove it? The courts have to be accepting of the fact that there are circumstantial evidence which can actually prove a crime, right? So we have to be accepting. We have to the superior court. It's a heavy burden is on high courts and supreme court to start interpreting law, start interpreting the rules for evidence. For example, she mentioned Sukra Bibi case, right? There are multiple FIR. The Supreme Court said that there cannot be multiple FIRs on one incident. It is the duty of the investigating officer to investigate all the versions available. It's a brilliant judgment, but it is whether is it being followed? It is not. On daily basis, we see a woman goes and lodges an FIR for an incident, and there is a counter FIR, ki ji wo khandani dushmani and all of that, and these are being registered. So we need to reform the system in a way where gender, the term gender, I find it insulting. As a lawyer, I say that there should be no gender, just as the law says, right? जो कानून है वो आपके हसब नसब जात सबसे बालातर है. आप कानून के सामने मुजरिम और मजलूम की कैपेसिटी में उसी कैपेसिटी में खड़े रहने चाहिए. औरत आदमी का डिफरेंशिएशन इज itself very wrong. So when we say gender based crime, we are actually yelling at the system, and we are trying to tell them that this is the problem that we have to talk about, that this is a gender based crime, so pay attention to it. This terminology itself problematic. It is itself problematic, and it is saying to the system that you need to pay attention, because a woman victim and a man victim should not be treated differently in the system. They should be treated on the same footing. For a judge, a female victim should not be seen as somebody, maybe she has done something, or maybe she has not done something, maybe she has consented. ये सारे notions judges के दिमाग में है. I as a prosecutor, I know it. I find it revolting that we stand in the same court where the judges are actually talking about these things, and trial court makes very normal. On the appearances, female witnesses and the victims are being judged. On the backgrounds, they're being judged. We live in cities. We don't know what goes in villages, and these very strong, brave victims coming out of these feudal systems and coming to court and fighting for justice. It is so difficult for them that we can't imagine, and we are not making the fight easy. We are making it even more difficult for them. When we say कि वो DNA नहीं collect हुआ था, तो हम आपका जो assailant है उसको छोड़ रहे हैं because आपने DNA evidence नहीं दिया. भाई उसको क्या मालूम है कि DNA collect करना था? वो तो आपके investigating officer का काम था ना, उसको करना चाहिए था collect. MLO का काम था, उसको collect करना चाहिए था. Victim की क्या responsibility है कि वो जाकर MLO को बताए कि जी मुझे इस तरीके से examine करो. ये तो standard बुक के रूल्स हैं कि MLO ने ये 15 चीजें करनी है, तो वो 15 चीजें करें. तो जब हम रिफॉर्म्स की बात करते हैं कलेक्शन ऑफ एविडेंस से पहले, आई थिंक बहुत इंपॉर्टेंट है कि वो कलेक्शन कैसे की जाती है. आप उनको वो सिखाइए, आप उनको इंफ्रास्ट्रक्चरल सपोर्ट दीजिए, आप उनको हम एविडेंस किट एक होती है, आई डोंट नो अगर आप लोगों ने सुना हो नहीं, एक एविडेंस किट होती है जो हर इन्वेस्टिगेटिंग
Unfortunately, I think Miss had dropped out. She was very rightly pointing out, even we had Miss Aruba a few days back, and she was talking कि कैसे अगर evidence kit नहीं थी तो झाड़ू की जो tinky हैं वो इस्तेमाल किए जा रहे थे for DNA, and that is indeed a very sad state of affairs. Miss Noor, if you can hear us, we would try to take on the conversation. So the fundamental question has been addressed, that there needs to be reform in evidence handling first, and of course in the police behavior, because they're the first step. Miss, there have been certain recent initiatives that have been taken by the police department, क्योंकि आपने law enforcement agencies के साथ काम किया हुआ है. They've increased female participation. They're all women police stations. How do you see these steps? How do you assess the effectiveness of these steps जो कि police ले रही है to enhance gender inclusivity in the police department? Do you think it's effective?
Miss Noor, can you hear us? No, you're not audible. And your video is stuck as well. If you can try reconnecting and then join back into the meeting. And in the meantime, I think we can have Ms. Mehrunissa's response on this question about, are there any anti-corruption strategies or practices that are already, in place that kind of reinforce the accountability mechanism of the police?
I think Farah will be better able to answer this question given her experience. But I will just say that, we've had some great steps coming forward. So Justice Aisha Malik's judgment about two-finger testing, that was a milestone. The anti-rape ordinance, which was introduced but has not yet been enacted, has some provisions which are very useful, and I think which are a step in the right progressive direction to ensure accountability. But I think what is needed is a complete change of attitudes of all the people involved in the investigation of these crimes. And I think, firstly, the most important thing that we need to do, we need to strengthen the role of the police as first responders. And I think there have been steps taken. So, for example, I think in Gujarat, they set up a women and juvenile facilitation center for cases of sexual and gender-based violence, which is a great initiative. So I think having more establishments like that across all provinces will be something that's very good. But other than that, I think having a system where there is more in the investigation and registering phase of the crime, having more interaction between the police and the judiciary. There have been amendments. So now, because initially we had a problem where the police would simply refuse to register an FIR. And now there's an option via an amendment where you can go to a justice of peace and they can actually give a direction to the police to register an FIR. While this is a great step, I think what would be even better, for example, is if in the power and the centrality of the FIR, if that is deconstructed or that is trickled down somewhat. So other than that, I think the use of modern technology and communication across different platforms and the registering of complaints and gaining of feedback across different platforms from informants, from people who are going through the system is something that can greatly benefit the criminal justice system as a whole. But I'm sure Farah and Noor will have more specific things to add to this point.
Thank you so much for your response, Ms. Mehrunnissa. And as you also rightly pointed out, there is something that's inherently, we need to work on, because the police are the primary investigative forces that are at play here, and the bottom of the criminal justice system starts with the enforcement mechanisms that are in place for the police. So, Ms. Noor, if you're here, can we also have your thoughts about this matter?
I'm not sure the extent to which I'm audible.
Yes, I can hear you.
And I'm deeply embarrassed because of my lack of internet connectivity and the recent bag search that I was doing while live on Facebook. I'm very apologetic. I think Mehrunnissa and Farah have largely covered all of the key issues, the pressing issues that women face today. I think what I would narrate from my own experiences is this hesitance to kind of pierce through the private sphere, and I feel like वहीं से सारे मसाइल शुरू होते हैं जब आप law enforcement agencies and खवातीन के मसाइल के interaction देखते हैं. I feel that whenever there is a case जो भी जिसमें किसी खातून की involvement होती है, तो उसमें the police, and it is a domestic issue per se, so the primary focus of the police is to always cause an intervention that will restrain her from pursuing any legal remedies. And I feel like that's where the problem starts. यहीं से जब ये प्रॉब्लम शुरू होती है, जब आप मोहरर के पास अगर जाएं और मोहरर से कहें जी कंप्लेंट लिखें, Mohrer is the person who's supposed to write down a complaint or listen to your complaint and help you author it. I feel that unme hi itni sensitization nahi hoti कि वो बैठे with a female complainant, someone who is not very equipped or as a lay person, so उसको समझ नहीं होगी कि उसने क्या details एक FIR में लिखनी है, क्या facts in an FIR लिखने that can make it worthy of an offense, right? That is prosecutable under a particular offense under the PPC. उसको नहीं पता, तो the Mohrer has the job, or any other law enforcement body, any police officer has the authority and the duty to sit with her, ask her about the facts of the case, extract the relevant information that is needed for a complaint that goes into the FIR. I feel that the police is significantly lacking the training in doing that. बेशक वो खातून हो या बेशक वो मर्द हो, मुझे लगता है कि क्योंकि एक ये जो हेजिटेंस है piercing in the private sphere और घरेलू मामलात में इंटरफेयर नहीं करना, या अगर किसी खातून का a woman is facing any sort of issue as a result of abuse by her husband, father, brother or anyone else, the police will not listen to the complaint long enough to be able to write it down in an FIR. The reluctance continues जब FIR रजिस्टर होने के टाइम पे आती है और आईओ ने इन्वेस्टिगेट करना होता है मैटर को. आईओ मैंने अक्सर देखा है, और मेरे साथ अभी रिसेंटली एक केस ये हुआ था that I had to go to थाना in इश्तर कॉलोनी. वहां पे एक केस था, एक खातून को अगवा कर लिया गया था और उसके बच्चे को भी साथ अगवा कर लिया गया था, and the mother had gone with me to register an FIR. From the Mohrer to the IO, everyone said, and this is not even on the basis of any investigation that they had done, this has just been on the basis of a complaint. They said, nahi, ye bhag gayi hai, ye bhag gayi hai, ye bhag gayi hai. ठीक है, even if these are the sorts of cases that you get in your thana or in your locality, that does not preclude every other woman from registering a complaint of the nature of the sort, right? Every woman has a right to register her complaint, and it is on the basis of an investigation that an IO is supposed to determine कि वो भागी है कि नहीं भागी. अगर वो लड़की एक statement दे देती है कि मैं अपनी मर्जी से गई हूँ, that's another story. But the reluctance to interfere is something that I've seen from the Mohrer to the very top court. Whether it is on the basis of a woman preserving her household or her household values, or on the basis of whether a woman should not be found in a courtroom or in a thana. And these attitudes are what inform women's lack of participation or women's inability to move forward with court cases. This is why हम देखते हैं कि जैसे ही केस अपनी ट्रायल की स्टेज पे पहुंचता है तो अक्सर लोग क्या करते हैं कि वो सेटलमेंट की तरफ सेटलमेंट रीच कर लेते हैं, या वो कहते हैं ओके फाइन लेट्स नॉट गो टू कोर्ट बिकॉज एक जिल्लत होगी, एक जिल्लत महसूस होगी. बच्ची के साथ अगर किसी किस्म की ज्यादती हुई है तो वो बच्ची को अदालत से घसीटेंगे, जजेस नहीं सुनेंगे, पुलिस बेइज्जत करेगी, पुलिस इनसेंसिटिव होके स्टेटमेंट रिकॉर्ड करवाएगी, एंड इन अ बिड टू प्रोटेक्ट वुमेन फ्रॉम ऑल ऑफ दैट कोई स्टेटमेंट रिकॉर्ड करने की तरफ आता ही नहीं है. And this, I think Farah ने इसको largely address किया in terms of evidence collection and how judges act when you are in fact in court, and how the police acts with you when you are in court. And I don't want to go further into that, but then I do want to go into how, tied in with the loopholes that Farah has discussed and Mehrunisa has discussed, any great legislation that we have that the parliament enacts for the protection of women, whether it is for honor killing, whether it is an anti-rape ordinance, or whether it is a law that protects women against acid crimes or anything else, I feel like is ineffective and completely toothless insofar as it is not implemented on the ground. A great example of this is a case study of the domestic violence law that was passed in 2016. Now, that domestic violence law is a wonderful law, right? Now, it faced a lot of resistance as well, and it's a wonderful law in that ठीक है, हम हथकड़ियां लगा देंगे मर्दों की एंकल्स पे, हम उनको घर से निकाल देंगे, हम ट्रैक करेंगे वो कहाँ जा रहे हैं. We're going to make XYZ authority here, we're going to make ABC authority there, and you're going to make thousands of authorities that are going to prosecute these offenses. But the problem with the law is that it can be only enforced where the government wants it to be enforced. तो वो कानून सिर्फ मुल्तान में है. अगर मैं domestic violence face कर रही हूँ, I'm a victim of domestic violence in Lahore, I cannot benefit from that law and the thousands of authorities that the law has set up, or that ankle bracelet that my husband is supposed to wear. None of that can happen for me, right? Equally, in the same vein, the non-criminalization of domestic violence has led the police to believe that yes, this is something that should not be interfered with on a criminal scale. It is something that can only be addressed within the realm of the home. That law today, because of these grave loopholes, remains unimplemented, and none of us sitting here, apart from a woman in Multan probably, या झेलम से अगर कोई खातून मुल्तान चली जाए, can benefit from that law. तो जितनी भी जेंडर ट्रेनिंग आपने वहां के अफसर को दे दी, अफसरान को दे दी वहां पे, तो उसकी एप्लीकेशन क्योंकि महदूद है, हम उस कानून का कोई फायदा नहीं उठा सके. इसी तरह ऑनर किलिंग का कानून आया. ऑनर किलिंग के कानून में बहुत अच्छी बातें की गई, राइट. फसाद फिलर, समथिंग दैट शॉक्स द कॉन्शियंस ऑफ द पीपल, इज एन प्रोसिक्यूटेबल ऑफेंस, जिसके लिए किसास और दियत परमिसिबल नहीं है. यू कैन नॉट कंपाउंड दैट ऑफेंस, एंड कोर्ट की डिस्क्रेशन पे है कि अगर कंपाउंड हो भी जाए तो क्या सजा देनी चाहिए. Great law, but that today we still see that the judiciary thinks that a man who is so grave and suddenly provoked by seeing his wife or his sister in an intimate act that shocks his conscience, and is that in of itself is such a legitimate defense कि वो crime of passion जो है जिसके तहत वो offense commit करता है, जो कि honor killing है, वो परमिसिबल है, उसको हम उसका सेंटेंस लेसन कर देंगे. क्योंकि एक हम सोसाइटी में, एंड दिस इज द 2020 डिसीजन ऑफ द सुप्रीम कोर्ट, कि हम एक सोसाइटी में कैसी रहते हैं जहां पे एक मर्द अपनी बहन को अगर देखे इन एन इंटीमेट एक्ट विद समवन, तो उसकी कॉन्शियस इतनी शॉक हो जाती है कि वो 2 मिनट नहीं सोचेगा, वो अपनी बहन का कत्ल करेगा. लेजिटिमाइजिंग दैट द सेंटेंस ऑफ द अक्यूज्ड वाज सिग्निफिकेंटली रिड्यूस्ड, and it was fine. So that patriarchal attitude, understanding that घरेलू तशद्दुद को रिपोर्ट करना is something that is dishonorable. एक खातून को कोर्ट आना या थाने आना is dishonorable. Disrespecting women till the top court. These are the things that we need to address, and we don't need more legislation. क्योंकि आप जितनी मर्जी legislation लें, आप chemical castration लें, आप anti-rape ordinance जैसे हजारों ordinances लें, अगर ये चीजें नीचे से एड्रेस नहीं होंगी तो इन कवानीन का हमें कोई फायदा नहीं है. ये कवानीन अच्छे लगते हैं, लेकिन आपके 3% प्रोसिक्यूशन रेट जैसे रेप केसेस में वो 3% ही रहेगा, वो 5% नहीं हो जाएगा. ये तब तक या वो 10% या 15 या 100% नहीं हो जाएगा जब तक आप नीचे से खवातीन को ये दिलासा नहीं देते और ये दिखाते नहीं हैं कि यस, this is how we are going to protect you. This is how, when an MLO sees you, they're not going to throw a form at you and be like, okay, go fill it out however you want to fill it out. आपके साथ कोई बैठेगा, आपको समझाएगा, आपके साथ आयो बैठ के आपसे तफ्तीश प्रॉपरली करेगा. ये नहीं, एंड इस तरह नहीं पूछेगा आपसे बैठ के, हाँ जी बीबी बताएं, अपनी मर्जी से गई थी, हाँ जी बीबी बताएं आपका इससे क्या ताल्लुक था, हाँ जी बीबी बताएं आपका कितने सालों से इस बंदे के साथ ताल्लुक था. This kind of attitude, this victim blaming, these leading questions are exactly what are an impediment to women in the legal system. These are exactly what are an impediment to women in prosecuting offenses. Equally, victims, हम victims की बात एक side पे करते. The next thing I really wanted to address was women who are victims of the criminal justice system itself, in that are victims who are accused of offenses and are victims of criminal justice delays, right? I think that two things that we often fail to address in light of the given, scenario जिसमें एक femicide चल रहा है, जिसमें हमारी law enforcement agency insensitive है, हम ये ignore कर देते हैं कि वो खवातीन जो accused हैं, जो under trial हैं, जो convicted हैं, उनके साथ क्या सलूक करता है criminal justice system. I remember there was a case that I was on in 2017, and this was a case of a woman who had been falsely accused of killing her husband when she hadn't. उसके भाइयों ने ही इस मर्द के अपने भाई को प्रॉपर्टी डिस्प्यूट पे कत्ल कर दिया, and that falsely implicated her. She was 14 or 15 at the time that she had been accused of the offenses. She was arrested. Now fast forward 15 years passed since her trial started, right? And she was not given any sort of recourse. 15 साल उसका केस चला. The court decided eventually that she was innocent, that she had not killed the husband, that DNA evidence proved that her fingerprints were not on the murder weapon, and that the trial court had erroneously implicated her of this offense. Now imagine 15 years have passed since a woman has been in languishing in jail, not knowing where her family is, not knowing where she will go after this. And there are thousands of women like this in languishing in prison, in Pakistani prisons right now. Because they either have no access to proper legal aid, they don't have access to knowing their rights or where their trial is at. मैं अक्सर कोर्ट लखपत जब जाती थी तो मुझे बहुत सी खवातीन तो ये बताती थी कि हमें पता ही नहीं है हमारा केस किधर है, हमारे वकील को पता है. There is no idea, they have no idea that they have been convicted and उनकी अपील चल रही है. They had no idea कि अगर एक केस था जहां पे एक लड़की had murdered her rapist, कि उसके वकील ने उसको as a defense ही नहीं यूज करने की कोशिश की. He pleaded insanity, right? Now these are the things that I feel like women are a victim of today, and women languishing in prisons are exactly what we all should need to cater to equally. We need, if there is something that needs to be reformed, it is not legislation that is on existing legislation on offences, but it is also to address issues like these. सुप्रीम कोर्ट में पिछले 10 साल से केस चल रहा है विमेन प्रिजनर्स का, वो आज तक आगे नहीं गया. उसमें सैकड़ों किस्म की रिफॉर्म्स की आइडियाज, रिफॉर्म की रिपोर्ट्स जा चुकी हैं, नॉट एड्रेस्ड. Your prison rules are pre-colonial edicts that you can no longer enforce because they violate most of your international commitments. Today, these are the things that we need to address as a nation, and these are some things that we can perhaps implement because prisons are both a legislative and an executive function, and parties can work together to in fact alleviate the issues that women face. इतने लंबे offenses चलना बेशक वो गलत हैं जब shows that there is a lapse even for not only victims but also women who are accused, and that's something that I feel that is important and we need to address today.
Thank you so much, Miss. You pointed very rightly that it's not just the victims, but also the accused that we need to keep in consideration when we talk about the criminal justice system, so to set things in the bigger picture. We are left with only 10 to 12 minutes, so we'll move towards the final question. Fatma, do you want to take this?
Yeah, sure. So, Ms. Noor, as you also rightly pointed out, the culture of victim blaming and how the rape victim is always blamed for the harm that she is, inflicted upon. I think kind of just jumping on the same line of thought, when you examine rape victims or when you examine victims of sexual assault violence as well, you always find that the medical legal examiners, there's no accountability mechanism for them. So, as we all know, Justice Aisha Malik passed the two-finger test. She abolished the two-finger test in the Lahore High Court, but yet we still don't know whether at the level of the hospitals, whether at the level of local clinics, if that judgment is being enforced or not. So my question to everyone who is currently on the panel is, what kind of accountability mechanisms or what kind of alternatives, now that the virginity testing has been banned, what are other sort of procedures that are in place that you think should be adequate enough for these medical legal officers to use and implement for victims of assault and victims of abuse?
Can I just
we have Pastor Mary response on
that. Sorry, someone was talking. Ms. Noor, was it you?
Yeah, I just want to clarify one thing.
Yeah.
Your question. I think one thing is, recently in 2021, there was a petition filed in the Lahore High Court before Justice Shan Gul, I assume, I think Meron Nissan can correct me on this if I'm wrong, where the petitioner contested that the two-finger test was not in fact being implemented in the Lahore and in the Punjab province, and how there was a large insensitivity towards victims of rape, and even in reporting, victims of rape were still being seen as the same kind, with the same lens of being blamed for the crime that they were, the crime that was inflicted upon them, right? So to that effect, I can say that the two-finger test is not being implemented, and this is still leading women to kind of compromise in a lot of cases before the case goes to trial. Recently, I know I was assisting in a case jahan pe a settlement was in fact reached for sexual assault, and because the victim just did not want to go to court, and this is after the abolishment of the two-finger test. And I think everyone can add more to this about how
Yeah.
judicial pronouncements even are not being implemented in the way that they should be.
Thank you so much, Ms. Noor, for your response. We'll move to Barrister Merunisa. Barrister Merunisa, just a little addition to Fatma's question. When we talk about trial, and during trial, especially of women or of like marginalized communities, when their trial is taking place, there are a lot of personal, maligned comments or character assassination. Although Justice Mansoor Ali Shah's judgment exists, which says that the character of woman cannot be brought to court during the trial. Do you think it is being properly implemented? And why do we still come across instances in which this practice is being repeated in court, creating an overall hostile and intimidating environment for victims?
So while I do think that because of such judgments and because of generally the fact that given Me Too, etc., there's a lot of discourse in the public mainstream about this, awareness is being created, but I do not think it is having the kind of effect in practice that we want to see. And one of the problems here is that instantly, even if someone is going and complaining about their former boyfriend, for example, or someone they were in a relationship with, being violent towards them, they hesitate so much because from the onset, the moment that you go even to the police station and you say, I was in a relationship with this person, or during the, God forbid, during the relationship, they were violent towards me, people here don't understand. And this attitude and this is something that carries on till the trial. So, I mean, even it's so unfortunate, but even in Noor Muqaddam's case, like recently, there has been discourse online where people are saying, oh, look, here's a video of her dancing with him from like a couple of weeks ago. I mean, this kind of dialogue, this kind of discourse, these kinds of comments, the very idea that what kind of any kind of relationship you had with a person who's then being violent, it's completely irrelevant. And this is something that I think our culture still fails to kind of wrap their heads around. And this is a highly problematic. Not only does it discourage women from reporting the violence or the abuse that they are facing, but this is an attitude that carries on in the court. I mean, the environment of the court for a female, survivor is intimidating enough, but even before and after the hearing, the kind of taunts that they face, the kind of discourse on social media like Twitter, etc., it has a hugely jarring effect on the woman. And also during the trial, the line of questioning that is often taken is extremely insulting. And someone who has been through something as traumatic as that, for them to stand there and answer questions about that, I mean, essentially, what are you trying to prove? If you're asking a woman who's been the victim of sexual abuse or violence, if you're asking her, what was your relationship with this person? Why did you go and meet him then? She immediately, she's already intimidated. She's already triggered. She's already reliving her trauma. For her to be asked these questions in an accusatory, very skeptical tone, what do you think that does to her confidence or her state of mind? It's disgraceful actually, that this kind of questioning is still being posed to survivors of sexual abuse and violence. So I think ultimately in our culture, till we realize and understand that as a woman, you have complete agency over your bodily integrity at all times, regardless of whether you have consented to an activity before. That does not imply consent in all subsequent meetings of yours with that person. And actually another thing that I would like to talk about, which is very important, is that we still do not criminalize marital rape. And even though the marriage exception was taken out of the text, like the definition of rape, we remove the exception of a man cannot do unto his wife, we still do not see anyone being prosecuted for marital rape. And this is again the same thing. It is absolutely the same idea that prevents us from criminal, because it's the idea that when you are entering into nikah with someone, you are signing away any control, any ownership over your bodily integrity to that person. Why is this such an offensive idea in our society that if a woman or someone's wife says, I do not want to indulge in intercourse with you right now, why is that such a trivial issue? No, but they're married, but he's a husband. What does that mean? I mean, the idea that you're in a relationship with someone or you're married to someone and you cannot say no, or that means that you lose agency or autonomy over any part, any aspect of your life, but especially your physical autonomy. Why is that something that is so difficult for our society to digest? And I think this is the main problem, and this is the problem that right from, the smallest kind of micro segment of society right up to the courts, this is the exact attitude that is replicated and that is reflected. You might have legislation saying, and you may have judgments saying that you do not look into or ask questions about the character or the past of a woman, but I mean, that is still a very deeply entrenched kind of case that we are operating from as a nation. Until there is a determined effort to do away with this, I think, honestly, justice for women in the criminal system is doomed.
Indeed, it is the societal attitude which is eventually creeping into the judicial structures, making things very difficult for women seeking justice. Unfortunately, we have very less time left, so we'll move to Advocate Farah Khan with the very last question for this session. Miss, whenever we see an incident like Noor Muqaddam's incident, there is a public outcry that increase the severity of punishments. इसको फांसी दे दें, नए कवानीन लाएं, सख्तियां बढ़ा दें. क्या आप इस सेंटिमेंट के साथ अग्री करती हैं कि कवानीन के अंदर सख्तियां बढ़ाने से क्राइम एक्चुअली कंट्रोल हो जाएगा?
डेथ पेनल्टी से ज्यादा सिवियर क्या सजा होगी?
जिस तरह
right, we already have it. You see, I don't agree with this notion कि सजाएं बढ़ाने से क्राइम कम होंगे. डिटरेंस का जो कॉन्सेप्ट है इस सोसाइटी के अंदर वो उल्टा ऑपरेट करता है. Meronisa has actually raised a very interesting point. We still don't understand the definition of rape. We think if somebody is not virgin, she cannot be raped. This is the understanding we have. And I think this is exactly what Justice Aisha wanted to eliminate from the system when she removed the two-finger test, because rape is a completely it's a forceful intercourse, right? It does not have to do with you being virgin or you being not virgin. It is about consent. It is about saying no to a certain act, and we still don't comprehend that. And I think I blame the legislation. I blame people who have drafted law. I blame those who are still okay with these badly drafted laws, which are not only pre-colonial but are also backdated. They come from a time where women had no voice. They come from a time where women has a very limited interaction in the society, and when woman was not actually, I'm very sorry I'm using this word, but a female or a woman in society was actually not treated as an individual और अ पार्ट ऑफ सोसाइटी, बट ऐसे जैसे भेड़ बकरियां होती है ना, उस तरह बस खवातीन भी थी. ठीक, उनकी कोई जस्टिफिकेशन उनके दिमाग में नहीं थी कि ये क्यों है, मगर वो बस थी. तो वो अनफॉर्चुनेटली हम अभी तक वही सिस्टम को फॉलो करते आ रहे हैं. आपका कानून शहादत एविडेंस का रूल बताता है, कहता है कि कैरेक्टर ऑफ अ पर्सन who's the party of the trial, चाहे वो कंप्लेनेंट हो या अक्यूज्ड हो, is not relevant. But at the same time, it says when it is a victim of sexual assault, it is a prosecutrix, her character becomes relevant. Why? Why do we have this law? When your Qanun Shahadat says that the judge should interfere in any question which is insulting, scandalous in nature, or harassing the victim, the judge should interfere. Why there is an exception provided that in case of a prosecutrix, that question becomes relevant? Why don't we have rules where which are general in nature? So I don't think that for deterrence we need to enhance any punishment, or we need to make more laws. As Noor pointed out, we have so many laws. We have such wonderful legislations. We have some brilliant laws available in Pakistan. We need implementation. The anti-rape ordinance, it is a brilliant law which actually provides accountability for an investigating officer who has actually manipulated the investigation or failed to conduct a fair investigation. But what happens? it doesn't get consented by the parliament. It was I just got to know that a lot of people from the opposition have actually dissented, and it was sad to see the names of those people, and they represent themselves, and they come from a society which is educated, and they are women empowering, and these are the people who are talking about, and they're coming from female leaderships. That is saddening. They're coming from female run political parties, and they're opposing the law which is actually protecting the oppressed woman in the society. We still have people like that. So for deterrence, what we need is a system where crime is seen as a crime, and it is not differentiated on the basis of its gender, on the basis of what profession the woman is. It is not based on what kind of a life she led. I mean, if we say that, and I always give this example to everyone. I teach criminal law to law students, and I give them this example whenever I'm teaching them crime against women. And I say that there is a documentary of TED Talks. I don't know whether you guys have seen it or not. They're trying to explain consent, and they have actually replaced the word consent with tea. So they're saying that if somebody comes to your house every day and you serve tea to them, and they just have the tea every day without objecting, it does not mean that if somebody someday he says that no, I don't want to have tea, you will force him. Nahi, tum roz peete the, tum aaj bhi hamare ghar baith ke chai piyo. It's simple as that. If a woman is having a relationship, if she is bold, if she, we have a problem with bold, outgoing, independent woman. This is something that we have it in our society. But that does not exonerate the fact that जो crime component है, Actus Reus and Mens Rea, the Commission of Crime, that is going to be there. हर कानून पीपीसी के अंदर मौजूद है. आपको नया कानून लाने की जरूरत नहीं है. पीपीसी में हर वो एक्ट जो इवेंचुअली जुर्म बन सकता है पाकिस्तान पीनल कोड के अंदर मौजूद है. चाहे वो पुलिस की खराब इन्वेस्टिगेशन हो, चाहे वो पुलिस का करप्शन हो, चाहे पुलिस की असिस्टेंस या एफिलिएशन हो टुवर्ड्स अक्यूज पर्सन, एवरीथिंग इज देयर. What we need is departmental implementation. When somebody approaches this SSP investigation with a complaint, Fatima, you have asked previously whether we have accountability for investigating officers. Yes, we do have it. We have accountability. You can write to the SSP investigation. You can complain regarding the conduct of the investigating officer. If he doesn't listen to you, you can file an application to the Justice of Peace saying that he's not doing the fair investigation or he's not acting in accordance with the law. We have everything available in the book. But what happened? Whether it gets implemented, it's not. The problem comes when we don't implement the existing law, when we don't actually take the pain of calling the investigating officer in the court and asking him, why didn't you do it? We don't ask these relevant questions to investigating officer. We wait till the conclusion of trial, जब वो अपने deposition के लिए investigating officer आएगा और डिफेंस काउंसिल जो है उसको कोर्ट में अपने कटहरे में खड़ा करके उसकी सत्यानाश करेगा बेसिकली, और फिर कोर्ट बोले कि जी अब तो आपका केस ही नहीं प्रूव हो सकता. तो कंप्लेनेंट का क्या कसूर था इसके अंदर? इस पूरे सिस्टम में हम ये मुझे बहुत एक अनफेयर चीज लगती है कि पूरा लीगल सिस्टम कहता है दैट अक्यूज्ड इज द फेवरेट चाइल्ड, and investigating agencies are politicized, and investigating agencies favor they actually make false cases, and people are lavishing behind the bars and this and that, and they're being falsely accused. Everything is there, but during this debate we forget one entity who's suffering from the very beginning, and that is the complainant, the person who has actually brought a genuine case before the court. Everybody wants to protect the right of the accused person, and they want to talk about the rights of accused person, but nobody wants to talk about the right of the victim or the complainant party who had no say in the system. Once the FIR is registered, everything is with the investigating officer. Previously, I think Sindh government ने एक suggestion दिया था of involving law officers in the police station. So they wanted a lawyer or a law officer to sit in every police station and actually monitor what happens in this, what goes around in the police station when somebody comes and registration of FIR. So the process, how the FIR is registered, and how investigation is being carried out. I don't know how effective that system is, but if you have plans like this, you should implement these plans. These plans should have been implemented. ये ऐसे सोच के बैठने की बात नहीं है कि अच्छा देखेंगे इसके ऊपर क्या होना है. ये बड़ी ज़रूरी चीज़ है. आप अगर इनके ऊपर अमल नहीं करेंगे तो इवेंचुअली आप सिस्टम को मज़ीद कंट्रोल मज़ीद ख़राब करते जा रहे हैं. नूर मुकद्दम जैसे इंसिडेंट जब होते हैं तो हमारा जो है ना वो कॉन्शियस जागता है और हम कहते हैं कि हाय बड़े जराइम है ख़वातीन के ख़िलाफ़ और इनको चौराहों पे फांसियाँ दें और इनके साथ ये करें, मगर आई एम वेरी सॉरी विद you know keeping all the sentiments, and I'm very passionate about this case myself. But having said that, and being part of the legal fraternity from past 8 years, I say that this is not the first time that it happened. We have seen incident where a minor child was actually thrown in front of dogs, trained dogs, just because उसका बाप 100 रुपए का उधार वापस नहीं कर पा रहा था. This is not the first time that happened in our society. So every single time when an incident takes place and every single person starts talking about more sensitive investigation or more severe punishments, that is not going to help or create the deterrence. We have to just make sure that absolutely the legal system is so blocked and it is so closed that an accused has no way to run from. Investigation is so concrete that he gets the punishment and everything is done on that timeline. 25 साल नहीं लगेंगे इस केस को डिस्पोज ऑफ होने में. ये केस जल्दी डिस्पोज ऑफ होगा ताकि लोग देखें, लोगों को याद रहे कि अच्छा ये नूर मुकद्दम का केस था, इसके अंदर ये सजा आई है. Right?
Sorry,
so this is what we need.
I'm sorry, Ms. Farah, I'll have to just interrupt here. And it's very
Tanya, I can also add one thing about Ms. Farah's response. I think, Ms. Farah, thank you so much for your insightful response. But ये जो आपने बात की about how there is a social issue and then there is a crime, right? Sometimes what happens is that the interplay between gender and crime is such that we as a society, we just bring our morals into it, right? Yeah. And we just start, and I think that's where the whole idea, the whole structure of victim blaming starts from, because our own opinions, our own religious beliefs, personal narratives about ठीक है उसको उसके घर जाना चाहिए था are all irrelevant, because right now we're talking about a crime and we're talking about the criminal justice system. So this is also something that you completely, absolutely rightly pointed out. This is something that the people of Pakistan who are right now victim blaming the poor girl who was brutally murdered, they should understand that as well. They have their own moral views about it, that's right, but a crime should be treated as a crime, and that's something that should be separated from the issue altogether, whether it was a woman or whether it was a man.
Well, thank you, Ms. Fatma. Indeed, it was very conclusive. I was also going to say the very same thing, but one more thing that Ms. Farah rightly pointed towards was that we do have laws. In most circumstances, there's extensive legislation present, but the problem lies with implementation and seriousness and willingness on the part of the executive to actually execute this legislation. Indeed, it is a very, very sad state of affairs today that the anti-rape ordinance is being opposed by certain political parties. And on behalf of Youth General Assembly, I would like to say that such bills, such important bills, when are politicized, it has a very far-reaching and detrimental impact on the women of our society, and that needs to be realized. This brings us to the end of the session. Indeed, it was an absolutely insightful, very intellectually invigorating session. Although I still believe that there are a lot of questions, Fatma would agree, that we really wanted to ask, but due to the very unfortunate time constraints, we have to end this session. I extend my most sincere gratitude to Barrister Mehrunissa Sajjad, Ms. Farah Khan, and Ms. Noor Ijaz, who joined us today. Thank you very much, Adil or Sehat Project, for collaborating with us. And Fatma, it was an absolute pleasure to have you with us today. You want to say anything?
Yeah, I'll just go ahead and say thank you to everyone who was on the panel today. I think this was a very insightful discussion. And when we were also kind of coming up with the topic, we realized that this was something that needs to be discussed. Absolutely, it was the need of the hour. And it's very important to have these meaningful and engaging discussions and to keep on raising awareness about these issues. So I'm really, really grateful, and I appreciate all of you guys for taking out your time for us today. And thank you so much, Hania. Thank you to the Youth General Assembly. On behalf of the Adil or Sehat Project, this was a very good collaboration as well. And thank you so much for taking out your time.
Thank you, Fatma. Thank you to all the panelists. It was absolutely to have you here. Thank you.
Khuda Hafiz.